Okay, let's unpack this. That sinking feeling when a deal you thought was solid starts looking shaky and you're suddenly facing the fine print. It can be, well, overwhelming, especially if you think something wasn't quite right from the beginning.
Definitely. Navigating contracts can feel like a minefield.
So today, think of us as your guides through a really specific, kind of tricky part of Philippine contract law. Voidable contracts. We're going to focus particularly on what happens when minors get involved.
Right. It's this idea of a contract that, looks okay on the surface. It seems to have all the essentials, but there's this hidden issue, this vulnerability.
Exactly. So this is our deep dive into voidable contracts under the Civil Code of the Philippines. We'll be zeroing in on legal capacity, specifically minority.
And for this exploration, we're leaning heavily on a very helpful reviewer by Isabel Laurel from the University of Asia and the Pacific Law.
Ah,
Yeah, her work really digs into the cases cited in Professor Balane's key text, Jottings and Jurisprudence in Civil Law, Obligations and Contracts, the 2020 edition, plus, of course, the Civil Code articles themselves.
and just so we're clear for everyone listening, that's Professor Balane.
Correct, Balane.
So our mission, if you like, for this deep dive, we want to pull out the core ideas about these voidable contracts, especially with minors.
Figure out what makes them different from, say, other contract problems. Maybe even touch on how they have this sort of built-in undo option for one party, which isn't the case for contracts that are just plain invalid from the get-go.
And crucially, what can you actually do if you're caught up in one? What are the remedies?
Okay, so let's start at the beginning. What is a voidable contract?
Mm-hmm.
Article 1390 of the Civil Code gives us the definition.
Right.
These are contracts that actually have all the essential elements.
Mm-hmm.
Consent, object, cause. They look valid,
But
but
yeah,
there's a flaw, a defect, in the consent given by one of the parties.
okay, a defect in consent, how does that happen?
Well, two main ways, according to Article 1390. Either one party lacked the legal capacity to give consent, think minors, for instance, or the consent itself was, well, vitiated.
Compromised. Vitiated. Meaning?
Meaning it wasn't given freely or with full understanding. Factors like mistake, violence, intimidation, undue influence, or fraud could be involved.
So it's not automatically void then, it's like it has a potential weakness.
Exactly, that's the key. These contracts are binding unless they are annulled by a proper court action.
They can work.
And they can be fixed.
Yes. Article 1390 also says they are susceptible to ratification. Ratification essentially cures that defect.
And Isabel Laurel's reviewer, it emphasizes this core problem is the quality of consent.
Precisely. It's an intrinsic defect right there in the consent element.
Laurel's review also pulled out some key characteristics.
It did. 4 main things to remember. 1, effective unless set aside by a court. 2, you have to challenge it directly in a specific lawsuit, not just as a side issue.
Okay, direct action. 3, the defect can be cured through ratification. And 4, only the party whose consent was flawed, the victim, so to speak, can actually bring the action to annul it.
Right. The other party can't just decide they don't like the deal anymore because the first party was a minor, for example.
Exactly.
Okay, let's zoom in on that first category. Lack of legal capacity. Article 1327 lists who can't give consent, and unemancipated minors are right there.
The general rule seems simple enough. Contracts minors enter into are voidable.
Seems straightforward, but I suspect there are twists.
Oh, absolutely. Philippine case law, especially 2 cases Professor Balane analyzes and which Laurel reviews, add some really important layers, particularly when a minor might have fudged their age a bit.
Ah, okay. Misrepresentation.
The first big one is Mercado v. Jose Espiritu from way back in 1917.
Mercado. What's the takeaway there?
So in Mercado, you had minors selling land, and they actively told the buyer they were adults. They misrepresented their age.
And the court said?
The Supreme Court said the sale was valid. And, crucially, the minors couldn't later turn around and use their minority to get out of the contract.
Why not? Doesn't the law protect minors?
It does, generally. But here, the principle of estoppel came into play. Because they actively lied and pretended to be adults, and the buyer relied on that, the court essentially said, you can't now deny what you asserted then. Laurel's review notes this clearly. The active misrepresentation bound them.
So actively deceiving someone about your age can actually backfire on a minor in contract law. That feels like a pretty big exception.
It is significant, and it's interesting to contrast it with a later case, Braganza v. de Villa Abril from 1959.
Okay, Braganza. How is that different?
In Braganza, a mother got a loan with her minor sons. the key difference. The sons didn't lie about their age, they just didn't say anything about it. They were silent.
And the outcome.
The Supreme Court took a different path. They said mere silence isn't fraud. So the minors weren't bound by the loan contract itself. They could use their minority as a defense.
That makes intuitive sense. Lying is active, silence is passive.
Exactly. And this is where Professor Balane's logic, as captured in Laurel's review, is quite insightful. He argues, quite logically, that if someone is too young to legally contract, how can they be mature enough to be legally estopped just by being silent?
That's a good point. If you lack capacity for one, you arguably lack it for the other.
Right. Balane questions if someone truly lacking capacity can be held to the standard required for estoppel through mere omission.
Does Balane suggest different rules based on how young the minor is?
Well, the Civil Code doesn't explicitly differentiate within minority itself. But Laurel's review mentions Balane's view, his scholarly opinion that maybe contracts by really young minors, what he calls minors of tender age, perhaps shouldn't even be voidable. Maybe they should be considered void from the start.
Like someone completely lacking mental capacity.
Similar logic, yes. That the incapacity is so profound, there's essentially nothing to even ratify later. It's a theoretical point, not explicit law, but it highlights the depth of the capacity issue.
Fascinating distinction. Okay, let's circle back to the Mercado case specifics. According to Laurel's review, what were the key facts again?
Laurel's summary lays it out. Domingo and Josefa Mercado, heirs to land with their sisters, sold their share to Luis Espiritu in 1910. Later, they sued to annul the sale.
On what grounds?
They claimed they were minors back in 1910, that Espiritu committed fraud and the price was too low.
But the court didn't buy it.
The Supreme Court ruled against them. No clear proof of fraud or even that they were minors in 1910. But more importantly, the court reinforced that doctrine. If minors actively claim to be adults when selling real estate, they're generally stuck with the deal.
So the act of misrepresentation was the linchpin in Mercado?
Absolutely. Laurel emphasizes the court's stance. Actively holding yourself out as legal age binds you to the sale.
Okay, now Braganza, the loan case. What happened there based on Laurel's review?
Laurel sums it up. Rosario Braganza and her minor sons, Rodolfo and Guillermo, got a loan. They defaulted. The lender sued.
And the son said, hey, we were minors.
Pretty much. And the Supreme Court agreed they couldn't be held fully liable on the loan contract because they lacked capacity.
But they didn't get off completely scot-free.
No, this is crucial. The court said they still had to return whatever benefit they actually received from the loan. This is called restitution. The idea is to prevent unjust enrichment. They shouldn't profit from the lender's loss just because they were minors.
So contract annulled, but they have to give back what they got. And the key difference from Mercado was silence versus lying.
Exactly. Laurel's review flags the Braganza doctrine. Failure to disclose minority isn't enough fraud to bind the minor to the contract itself. But Article 1340, which Laurel notes applies even to unenforceable contracts, kicks in regarding restitution.
Article 1340.
Right. It basically says a minor has to return whatever they profited by to the extent they profited. It bridges the gap in Braganza, no contract liability, the liability to return the benefit.
Okay, this seems like a good moment to clarify something. We're talking voidable contracts due to minority. How is this different from a rescissible contract? I know Laurel's review doesn't focus there, but the idea of undoing a contract seems related.
That's a really important distinction to make, yeah, because undoing sounds similar. But the reason is different. Voidable contracts, like we've been saying, have that defect from the start in the consent or capacity. They're flawed internally.
Okay, defect deformation.
Right. Rescissible contracts, on the other hand, are actually validly formed. All the essential elements, including consent, are fine initially. The problem comes later, or rather, the effect is the problem.
What kind of effect?
They cause a specific kind of economic damage or prejudice. Think of a guardian selling a minor's property for way less than it's worth, causing significant financial loss, or someone selling assets to defraud their creditors. The contract itself was validly agreed upon, but the law allows it to be rescinded because of the harmful economic consequences.
So voidable, initial defect in consent capacity. Rescissible is field formation, but causes economic harm specified by law.
You got it. That's the core difference. Our focus today is squarely on that first category, the voidable ones with the built-in flaw.
Perfect. So going back to Professor Balane's analysis via Laurel's review, he really seems to emphasize that active lie versus silence distinction.
Very much so. Laurel points out Balane sees Mercado as grounded in estoppel. You lie, you're stuck. But he strongly backs Braganza. Mere silence shouldn't negate the fundamental lack of capacity of a minor.
And his tender age idea adds another layer to that capacity question.
Exactly. It pushes the thinking on whether any contract by a very young child should even be considered voidable or just plain void. It's about the very possibility of consent.
Now, Laurel's reviewer also walked through some key civil code articles. Let's quickly touch on those.
Sure. Foundational is Article 1318, consent is essential. Then 1327 lists who can't consent, including unemancipated minors.
We mentioned 1340 regarding restitution.
Yes, making minors pay back the benefit received. Then there's Article 1391, which sets the time limit, the prescriptive period, to file for annulment.
How long is that?
4 years. But importantly for minors, that 4-year clock only starts ticking after they reach the age of majority or their incapacity ceases.
Okay, so they have time after becoming an adult to challenge contracts made during minority. What about fixing these contracts? Ratification.
Right. Articles 1392 to 1396 cover ratification. It's the act of curing that defect, making the voidable contract valid.
How does that work? Are there conditions?
Yes, Laurel's review outlines them. The contract must be voidable, obviously. The person ratifying must know about the defect and do it consciously. It has to happen after the reason for voidability ends, like reaching adulthood. And it must be done by the party whose consent was defective or their guardian.
What happens once it's ratified?
Two main effects. It's curative, the contract becomes fully valid, and it's retroactive. It's considered valid right back to the day it was originally made.
Can ratification be implied? Or does it have to be explicit?
It can be either, according to Laurel's summary. Express is a clear statement. Tacit is through actions that clearly show intent to be bound, like fulfilling the contract obligations after turning 18. Article 1394 also covers ratification by a guardian while the person is still incapacitated.
Okay, so if it's not ratified, the option is the action for annulment. Articles 1397 to 1402. Who can actually sue?
Article 1397 says the party whose consent was defective or who lacked capacity, or sometimes people subsidiarily liable. But remember, the capable party can't sue based on the other party's incapacity. And if you cause the fraud, you can't use that fraud to annul the contract.
Makes sense. What happens if the court does annul the contract?
Article 1398 kicks in. Mutual restitution. Basically, everyone gives back what they received under the contract. The thing, the money, plus any fruits or interest.
But wasn't there a special rule for minors, like in Braganza?
Yes, absolutely critical. Article 1399 limits the incapacitated person's obligation. They only have to restore to the extent they were benefited by what they received.
Ah, so if they squandered the money, they might not have to return the full amount.
Precisely. It recognizes their limited capacity and protects them from undue hardship. Laurel's review notes this shields them from the same level of responsibility as an adult.
What if the thing to be returned got lost?
Articles 1400 and 1401 handle that. The rules depend on whose fault caused the loss and whether the party was in good or bad faith. It's a bit detailed there.
And finally, what if one party just refuses to return what they got?
Article 1402 addresses that. If one party doesn't restore, the other party can't be forced to restore either. It ensures a level playing field in the unwinding process.
Okay, so summing up this deep dive. Voidable contracts, especially with minors, have these really specific rules in Philippine law. There's this balance, isn't there? Protecting minors, but also considering things like active misrepresentation.
Absolutely. The law tries to protect those lacking full capacity, but it's not a blank check. Cases like Mercado and Braganza, as analyzed by Balane and reviewed by Laurel, really show this tension. Estoppel versus fundamental incapacity. Restitution playing a key role.
It's about safeguarding vulnerable people, but also trying to maintain some stability and fairness in agreements. That difference between active lying and just being silent is a prime example.
It really is. Understanding these nuances as estoppel, the limits on restitution for minors, it's crucial because it's not just about tearing up the contract. There are consequences.
Definitely. And that brings us to maybe a final thought for you, the listener, to chew on. How do these principles developed over decades apply now in our digital world?
Yeah. Think about online transactions, age verification, often flimsy, right?
Mm-hmm.
What responsibility do platforms have when minors click, I agree, to terms they can't legally consent to?
What are the implications for kids buying things online, signing up for services? It's a whole new frontier for these old legal ideas about capacity and consent.
A really interesting space to watch, where the law is still catching up with technology. Something to keep thinking about.